So once again, I am Danica Gabriel Roado together with my colleagues Mr. Walo, Miss Homalan, and Miss De Plas. I will be reporting about the anti-mail order bride law. So this is an act to declare unlawful the practice of matching Filipino women for marriage to foreign nationals on a mail order basis and other similar practices, including the advertisement, publication, printing, or distribution of brochures, flyers, and other propaganda materials in furtherance thereof and providing penalty therefore. So, um, it also prohibits to enlist in any manner to attract or induce any Filipino woman to become a member in any club or association whose objective is to match women for marriage to foreign nationals, either on a mail order basis or through personal introduction for a fee. So, even postal service to promote such prohibited acts is also prohibited. If a person is found guilty by the court to have violated any of the acts herein, they shall suffer an imprisonment of 6 years and 1 day, but not more than 8 years, and a fine of not less than 8,000 pesos, but not more than 20,000 pesos. And if the offender is a foreigner, he shall be immediately deported and barred forever from entering the country after serving his sentence and payment of fine. um, all laws, decrees, instructions, and regulations of parts thereof inconsistent with this act are hereby repealed or modified accordingly. Nothing in this act shall be interpreted as a restriction on the freedom of speech and association for purposes not contrary to law as guaranteed by the Constitution. It is the policy of state to ensure and guarantee the enjoyment of the people of a decent standard living. Towards this end, the state shall measure to protect Filipino women from being exploited in utter disregard of human dignity in their pursuit of economic upliftment. Our next topic is the Anti-Sexual Harassment Law or the RA 7877. So, this is an act declaring sexual harassment unlawful in the employment, education, or training environment and for other purposes. Actually, under RA 7877, sexual harassment is defined as or may be defined as being committed by an employer, employee, manager, supervisor, agent of the employer, teacher, instructor, professor, coach, trainer, or any person who, having authority, influence, or moral ascendancy over another in a work or training or educational environment, demands, requests, or otherwise requires any sexual favor from the other, regardless of whether the demand, request, or requirement for submission is accepted or not by the object of the said act. Um, how is work-related sexual harassment committed? So, actually, it's committed if the sexual favor is made as a condition in the hiring or in the employment, re-employment, or continued employment of said individual, or in granting said individual favorable compensation, terms, conditions, promotions, or privileges, or refusal to grant the sexual favor results in limiting, segregating, or classifying the employee, which in any way would discriminate, deprive, or diminish employment opportunities or otherwise adversely affect said employee. These acts, which would impair the employee's rights or privileges under existing labor laws, or the above acts, would actually result in an intimidating, hostile, or offensive environment for the employee. The Declaration of Policy of RA 7877 states that the state shall value the dignity of every individual, enhance the development of its human resources, guarantee full respect for human rights, and uphold the dignity of workers, employees, applicants for employment, students, or those undergoing training, instruction, or education. Towards this end, all forms of sexual harassment in the employment, education, or training environment are hereby declared unlawful. Okay. So, As discussed earlier, sexual harassment can be related in work. It can also be related in education or training. So, how is education or training related sexual harassment being committed? It may be committed against one who is under the care, custody, or supervision of the offender, against one whose education, training, apprenticeship, or tutorship is entrusted to the offender, when the sexual favor is made a condition to the giving of a passing grade, or granting of honors and scholarship, or the payment of a stipend, allowance, or other benefits, privileges, or considerations. Or when the sexual advances result in intimidating, hostile, or offensive environment for the student, trainee, or apprentice. Actually, a person who directs or induces another person to commit any act of sexual harassment or who cooperates to commit the act, without which the said act would not have been committed, will also be held liable under the law. A person found guilty of sexual harassment shall be penalized by imprisonment of not less than 1 month, nor more than 6 months, or a fine of not less than 10,000 pesos, nor more than 20,000 pesos, or both. There is a duty of an employer of head of office in a work or education or training environment. The employer or head of office is required by law to prevent the occurrence of sexual harassment acts and to provide the procedures for the resolution, settlement, or prosecution of sexual harassment. Towards this end, the employer or head of office shall actually promulgate appropriate rules and regulations in consultation with and jointly approved by the employees or student or trainees. Through their duly designated representatives, said rules and regulations shall prescribe the procedures for the investigation of sexual harassment cases and administrative sanctions. These sanctions shall not be a bar to prosecution in the proper courts for unlawful acts of harassment. So, actually, RA 7877 provides that nothing in this act shall preclude the victim of work, education, or training related sexual harassment from instituting a separate and independent action for damages and other affirmative relief. Question: can an offended party seek redress by taking an independent action? Definitely yes, the offended party may take independent action for damages in act of sexual harassment. Okay. And where do they go for help? They may contact the government sector employees such as the Civil Service Commission, the Department of Labor and Employment, the Philippine National Police, the National Bureau of Investigation, and the DOJ through the Public Attorney's Office. RA 877 mandates that employer or the head of work, education, or training institution duties in ensuring and enforcement of the act. Okay. So this is stating that in the case of the educational or training institution, and there should create a committee on decorum and investigation, or also called as CODI. Okay. So it shall be composed of one representative from the administration, the trainers, the teachers, the instructors, professors or coaches, and students and trainees as the case may be. While for work-related environment, the committee shall be composed of at least one representative, each from the management, the union, the employees from the supervisory rank, and from the rank and file employees. So this CODI, or Committee on Decorum and Investigation, shall conduct meetings, or as the case may be, with officers and employees, teachers, instructors, professors, coaches, trainers, and students or trainees to increase understanding and prevent incidents of sexual harassment. It shall also conduct the investigation of alleged cases in constituting sexual harassment. So once again, this is RA 7877, Anti-Sexual Harassment Law.